Today, in genuinely shocking news, the conservative majority Supreme Court ruled 5-4 in favor of black voters in a congressional redistricting case in Alabama, with two conservative justices, Roberts and Kavanaugh, joining the three liberals in rejecting a Republican-led effort to weaken a landmark voting rights law. It definitely tells you something about the standing of the court when there is shock that they didn't further gut American voting rights. The heart of this case was whether Alabama had unfairly carved up its congressional districts, creating just one majority black seat out of 7 in a state where more than 1 in 4 residents is black. The state claimed they used a race-neutral benchmark last year. A lower court with 2 Trump appointees on it ruled that the map violated the Voting Rights Act by diluting the votes of black Alabamians and ordered them to redraw it. The ruling was stayed by the Supreme Court using its infamous shadow docket, effectively helping Republicans win back the House majority. During oral arguments, it sounded like the majority of justices agreed with Alabama. But it is possible that Chief Justice John Roberts recognized the precarious position that the court stands in with the public following the overturning of Roe v. Wade and a string of ethics scandals. Now, whatever was behind the 5-4 surprise vote, Alabama will now have to draw a new map for next year's elections. This ruling will undoubtedly impact similar cases in Louisiana and Georgia. And in a plot twist, Roberts, who wrote the majority opinion in the Shelby case that gutted the Voting Rights Act, wrote the majority opinion today. He wrote, "The heart of these cases is not about the law as it exists. It's about Alabama's attempt to remake our Section 2 jurisprudence anew. That single-minded view of Section 2 cannot be squared with the VRA's demand that courts employ a more refined approach, and we decline to adopt an interpretation of Section 2 that would revise and reformulate threshold inquiry that has been the baseline of our Section 2 jurisprudence for nearly 40 years. Basically, he's relying heavily on stare decisis, the magic words, which basically means that courts and judges should honor precedents. Notably, they didn't care about stare decisis when they overturned Roe. That said, this is very good news, and we'll take it. But that doesn't mean we're out of the woods. Kavanaugh, while siding with the majority, signaled that he is willing to blow up the Voting Rights Act in the future, writing separately. Even if Congress in 1982 could constitutionally authorize race-based redistricting under Section 2 for some period of time, the authority to conduct race-based redistricting cannot extend indefinitely into the future. And then there was Clarence Thomas, who continues to make it clear to make clear the irony that despite being one, to paraphrase pre-Trump Kanye, Clarence Thomas doesn't care about black people. In his dissent, he wrote, "A proper districting benchmark must be race neutral. It must not assume a priori that an acceptable plan should include any particular number or proportion of minority-controlled districts. In its main argument here, Alabama simply carries these principles to their logical conclusion. We indulge the pernicious tendency of assigning Americans to creditor and debtor races, even to the point of redistributing political power on that basis." Joining me now is Elie Mystal, justice correspondent for The Nation, and Maya Wiley, president of the Leadership Conference on Civil and Human Rights. I am going to come to the table to you first, because I think we share a similar view that this might have been a face-saving ruling, but what is your view of why it went this way and why those two justices went with the liberals?
Yeah, first of all, to be clear, I am shocked, right? John Roberts has been an enemy of black people voting rights for his entire career, all right? And this Supreme Court has either rejected or whittled down the Voting Rights Act at every opportunity it's had since Robert came on the court until today.
Yeah.
So, jaw off the floor, okay, pretty shocking. Why? Well, let's go back to Clarence Thomas's dissent, right? He's talking about a race-neutral benchmark. Well, how do you set up a race-neutral benchmark? Alabama said, use these computers. We've run a bunch of computer programs, and this is what it is, and blah, 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 blah. And John Roberts hates computers like John Connor hates computers in the Terminator series, all right? Now, I always thought the Roberts hated black people more, but it turns out that when you tell John Roberts that a computer can tell you what's race neutral, Roberts understands, well, that means the computer can tell you what's racist. And that means judges don't get to make the final decision on how much racism is allowed in voting. That means potentially a computer would get to make that decision. And John Roberts doesn't like the computers. He doesn't like math. And I think more than anything else, that's why Roberts went against his own type, against his own prior arguments to uphold the Voting Rights Act after a career of trying to destroy it.
Very interesting. He thinks AI is going to replace the court, which actually might be a better outcome. Maya, let's go into this because Alabama, I'm just going to put up a map here that shows how egregious this is. You and I have talked about this before in Alabama. These, if you guys can see it there, the purple shows you black representation and how that big circle is around all basically where the black folks live, and they're all packed in one district. That's 27% of the population. They get one member of Congress. Talk about this ruling from your point of view as somebody who's fighting this fight on the ground in the courts.
Yeah, well, first let me say I agree with Ellie. We were all shocked and surprised, happily and pleasantly, because the Supreme Court did the right thing. But it's exactly because of that map. Because, look, 27% of the population is black. In 1982, when Congress amended the Voting Rights Act of 1965, it said, look, voter dilution, no go. You can't just dilute black people's vote. And what the court did, the Supreme Court said in its precedent is right. You can't dilute the black vote. And here are the ways in which we look to see whether we do that. In Alabama, we saw an 80,000 person increase in the size of the black population between the 2020 census and the previous decennial census. That means the population number goes up. You should be able to see more opportunity for black people to have the ability to select who leads them. And instead, what we saw is the state legislature saying, actually, no, we're going to find a way to make sure that there's less ability, not more ability, for blacks to be able to say who leads them. By the way, if we were truly a country that said we need to make sure that we're being fair, that we're being just, how would we ever go into any community of any other racial group and say, you know what? We're going to either pack you all into one district and then split the rest of you up so that even if you're a third of the state, you can send one member to Congress out of 5. That is simply, clearly on its face, an effort to say we just don't like who you vote for, and we want to make sure you can't actually undermine us, the powerful few.
And in this case, it's 1 out of 7. And Mississippi has the same scheme. They got 1, and so this actually could impact other states. Louisiana, same thing. You have, the South is where half of African Americans live, and yet in all of these states, they get 1 member of Congress. They put all the blacks in there, South Carolina, all these states, you get 1, and they split up the rest, which is completely, what I do wonder, because this could actually result in up to like 8 more members of Congress who are African American. But I will note that this Supreme Court let that map lie in 2022, along with the illegal Florida map. So they engineered Republican outcomes, even as they're supposedly fixing.
You saw what they did there, huh?
I did.
Because what happened was that this map was sued before the midterms, right?
Yeah.
And the lower court said this map is clearly racist before the midterms. And it went up to the Supreme Court, and by a vote of 5-4, with Roberts actually also saying this was a bad decision, Brett Kavanaugh was the swing vote, and he allowed Alabama to use its racist maps for the last election, which helped Republicans gain control of the House. And it's Brett Kavanaugh who looks like the buffoon right now for flipping at the late date. So now it's all like, oh, well, it was clearly racist. Looks like the district court was right all along. But it turns out that Alabama got this whole federal election cycle with a racist map.
There's so much to talk about because, first of all, it feels like a setup a little bit because they have a whole bunch of other cases like affirmative action, and all sorts of other stuff coming down the pike that they could actually really hurt folks on. And so it feels like that could happen.